Mr.
That
Sweeney?
wasn't contemplated in the plea agreement. It's not being recommended, Your Honor.
Very well. Mr. Levitt, your recommendations regarding an appropriate sentence?
These are joint recommendations of the parties, Your Honor. I would point to the timely entry of a plea, the fact that the county attorney's office was never had made
A
to
high-speed DUI case is heading toward a negotiated resolution. But don't mistake this for a routine hearing. The defendant faces serious allegations, and the judge will soon examine whether this plea deal truly fits the facts. Stay tuned for every twist, and subscribe for more dramatic courtroom breakdowns today.
Brett Sweeney appearing for the state of Kansas. Matt Levitt as defense counsel. Defendant Phillips appearing in the office of his lawyer, all by Zoom. This matter comes before the court at this time for arraignment. The court's docket notes indicating that there was waiver of preliminary hearing back on March the 18th. Arraignment was set for today. Mr. Levitt, does your client desire the charging document to be read to him?
No, Your Honor. We acknowledge receipt of the information and would waive formal reading of the same.
What plea is being entered at this time?
Judge, we are prepared pursuant to negotiations to enter a plea to count 2. That will be a no contest plea. We will stipulate to the affidavit of probable cause as a factual basis. It is my understanding that in exchange for that plea, counts 1, 3, and 4 will be dismissed. The parties have a joint recommendation to the court of standard terms and conditions for a DUI, which is pled as a first offense, Class B misdemeanor. That would be a 6-month controlling jail term with 12 months of reporting probation, anticipated through court services. Follow all of the recommendations of the drug and alcohol evaluation. That is through a clear direction and was forwarded earlier today to your administrative assistant as well as to Mr. Sweeney. It contemplates an ADSAP program and 4 to 6 weeks of required aftercare. All other standard terms and conditions would apply. We are anticipating a fine of $750 in this matter.
Okay. Alcohol and drug safety action program, then 4 to 6 weeks of aftercare after that?
That is specifically what on page 1 under recommendations, it said, recommending the 1-day education course, paren, ADSAP, close paren, and 4 to 6 sessions of aftercare. I'll note to the court that a Clear Directions level 1 outpatient treatment program has consistently been 8 weeks or more. 4 to 6 is typically what we would see on a traditional level 1. So while I have not specifically spoken to Mr. Williams, the evaluator, I anticipate that he is treating this more like a level 1 outpatient treatment program, but without the sort of escalator that I have seen their office put on things. So more of a traditional 4 to 6 weeks of what would be treatment. He is describing it as aftercare.
All right, very well. Mr. Sweeney, you've heard Mr. Levitt's statement to the court. Do you disagree with any of those statements?
No, Your Honor. I think all that's accurate and consistent with the plea agreement.
Mr. Phillips, it's the court's understanding that you would resolve your case by now entering a plea of no contest to count 2, driving under the influence, a Class B non-person misdemeanor, punishable by a minimum fine of $750, maximum fine of $1,000. Also, there's at least 48 hours of confinement, which is required by that statute, and up to 6 months in jail is authorized. Do you understand these things?
Yes, I do, Your Honor.
All right. While there's an attempt here to bypass any statement regarding a factual basis by reference to an affidavit, Mr. Sweeney, I'm going to ask you to provide a brief statement of factual basis behind a driving under the influence charge in this case.
Yes, Your Honor. So the state believes that if presented at trial, the evidence would essentially be that on February 6, 2026, at approximately, it looks like 11:33 p.m. at US 54 and Southwest Santa Fe Road, The officer noticed a vehicle traveling 85 and a 65, tried to catch back up with that vehicle. That vehicle reached speeds that they guesstimated were at 100, over 100 miles an hour. They were eventually able to stop the vehicle, pulled that individual over. They initially observed what they believed were indicators of impairment, ran them through some field sobriety tests, and based on the findings within the field sobriety tests, including some slurred speech as well, they determined that they felt like he was under the influence of alcohol and or drugs. Additionally, they found a substance that was consistent with cocaine powder inside of the vehicle. So given the close connection between the narcotics in the vehicle, the slurred speech, the failed field sobriety test, and the driving, I think that would suffice for factual basis.
Very well. All right, Mr. Phillips, do you now freely, knowingly, and voluntarily enter a plea of no contest and accept conviction for Class B misdemeanor driving under the influence?
Yes, I do, Your Honor.
Very well. Court finds that this is a free and voluntary act on the defendant's part. He's been made aware of the possible penalties, and there is a factual basis supporting the charge. The court will accept his plea of no contest, find him convicted of driving under the influence, a Class B misdemeanor, and dismiss all other counts of the information pursuant to plea agreement. We will proceed to sentencing at this time. Mr. Sweeney, what are your specific recommendations?
Yes, Your Honor. So consistent with what's previously been announced, the state's recommending a 6-month underlying. State's recommending a $750 fine, which is, of course, contemplated by the statute. Court costs, standard costs and fees above and beyond that. We're asking that the defendant be placed on a 12-month court services probation. We would ask that he comply with the recommendations of the clear direction report. I'm glad the court asked because I was a little bit confused as to what exactly that was recommending as well. But just that he follow through with that and then keep his CSO and stay in communication with the CSO regarding his compliance with that. DUI victim panel is pretty standard. We would ask for that. Standard conditions of a court services probation above and beyond what's already been mentioned. I don't think I have anything further above and beyond that. Thank you, Your Honor.
You're not recommending any further service of jail time, Mr. Sweeney?
That wasn't contemplated in the plea agreement, and it's not being recommended, Your Honor.
Very well. Mr. Levitt, your recommendations regarding an appropriate sentence?
These are joint recommendations of the parties, Your Honor. I would point to the timely entry of a plea, the fact that the county attorney's office was never made to prepare, call witnesses, including the voluntary waiver of a preliminary hearing. So thus the timely acceptance of responsibility. I would also point to the fact that Mr. Phillips has done everything that has been asked by me in order to prepare for these matters. He has shown up to every single court date. I believe him to be amenable to probation. On the issue of the jail time, the July 2022 revision of 8-1567 under B1A seems to contemplate the 48 hours nor more than 6 months imprisonment now as a controlling jail term. And I would point to the B subsection I, as well as the 2 or double IA, which talks about condition of probation granted under the subsection on second or subsequence, where the mandatory minimums, what we normally used to consider as the mandatory minimum jail time, now only is contemplated on second or subsequence under that subsection of the actual statute itself, which is not contained under the B1A. So I believe that the legislature eliminated the mandatory minimum as it pertains to actual custodial time that must be served either prior to probation being granted or alternatively with regards and with respect to as a condition of probation. So I believe that this is a legal sentence that's contemplated by the parties, and we are asking the court to follow the same.
Does this defendant have any accrued jail time credit on this case?
May I inquire just briefly, Judge? I'm going to mute the audio.
You may.
The defense is making a crucial legal argument here, claiming Kansas law no longer requires additional mandatory jail time for this first offense DUI. That could significantly affect the outcome. The defendant's cooperation and early plea are being highlighted, but will the judge agree that probation alone is enough punishment?
And Mr. Phillips and I have discussed this. He was held in custody prior to actually coming up before the court from approximately Friday, and I realized this may have been Sunday or Saturday early morning hours until Monday when he made a first appearance. So he did spend approximately 48 hours in jail upon arrest. And I see Mr. Sweeney nodding his head along, so he may very well be in agreement to the same.
I think that's accurate, Your Honor.
Very well. This time then the court will address the defendant Chad Phillips personally and ask him if he has any statements that he wishes to make in mitigation of punishment or anything further that he would like to present to the court.
No, I would not like to, Your Honor.
Okay, can he start over? Because he was muted for a while.
No, I would not like to.
Very well. Court will pronounce sentence in this case. For Class B misdemeanor, driving under the influence, the court imposes 6 months in the Butler County Jail, imposes a fine of $750. The court will grant the defendant 12 months probation to be supervised by the Court Services Department. He's to follow standard conditions, complete and document completion of a DUI victim panel presentation. Court will also order him to complete an ADSAT program and then have 4 to 6 weeks of aftercare sessions as recommended by his evaluator. Court will assess misdemeanor docket fee, misdemeanor probation fee. I note Mr. Levitt is retained counsel, so there won't be any bids assessments necessary in the case. Are you aware of any other costs which this court should contemplate, Mr. Sweeney?
No, Your Honor. There was no KVI or anything of that nature. So if there was, it was on dismissed counts. So no, Your Honor, I'm not.
All right. I would also require the county attorney's office to research and document within the journal entry which stems from today's proceedings any accrued jail time credit this defendant has earned. Mr. Phillips, I'm placing you on probation at this time, but quite frankly, had you not done any jail time as a prelude to your first appearance, this court would be ordering some today. This appears to be a more flagrant situation than many driving under the influence charges. However, it's your sole count of conviction. I hope that 2 days or whatever you spent in the county jail was some of the most miserable time that you've ever spent in your life, and that you never want to repeat that again. I hope that that's the experience you had. I wouldn't want that to have been too convenient of an occasion for you. You can't drink and drive ever. It's an extraordinarily dangerous activity, and that's why the legislature attaches the penalties to it that it does. So this will be an outright grant of probation. I will require the defendant, and I think you should do that while you're in Mr. Levitt's office, Mr. Phillips, to contact the Court Services Department of Butler County immediately after today's hearing. Mr. Levitt can fill any gaps that may exist when they ask questions regarding the sentence. I think that number is area code 316-322-4153. 322-4153. Mr. Phillips, you're required to contact the Court Services Department immediately after we recess court proceedings here today. As far as payment of the matters that the court has made orders on, what is suggested here, Mr. Levitt? What are your client's intentions?
Mr. Phillips informs me that if the court, he believes that he can pay the full amount of the fines and court costs within approximately 60 days' time.
All right. Court will require the defendant to pay the case off in full within 60 days of today's date. No action on collection will be taken during that 60-day period. I do appreciate a rather aggressive, compared to many cases, approach taken by the defendant in this case to at least get the financial part of this case taken care of. I think it'll be pretty close to $1,000 total. And I trust that's what you were contemplating, Mr. Levitt.
Yes, Your Honor. We had discussed not only the mandatory minimum fine of the $750, but also what the court costs might run.
All right. I came up with a rough computation of $968, but I don't know if my math is correct. I'm sure the county attorney's office will have a correct number in the journal entry, which stems from today. Mr. Sweeney, are you seeking additional orders in the Phillips case at this time?
No, Your Honor. Thank you.
Mr. Levitt, anything further that the court needs to address?
No, Your Honor. Thank you.
Mr. Phillips, do you have any questions regarding the court sentencing orders?
No, I don't, Your Honor.
I hate to use a term like lucky, Mr. Phillips, but the outcome of your case, you are extremely fortunate to get this outcome. Thank Mr. Levitt for his services in the negotiation and the handling of your case. And I hope, really for your sake, that you don't have to come back before this court on a review of this sentence. Good luck. I hope you're 100% successful on this probation program. And then make that call as soon as we recess.
We will, Judge. Thank you.
Thank you. Thank you, Mr. Levitt. If there's nothing further, the Chad Joseph Phillips matter will currently be in recess, and this meeting may be ended for all.
What a remarkable finish to this case. After hearing about dangerous driving, alleged impairment, and the circumstances surrounding the arrest, the judge still grants probation and emphasizes how fortunate the defendant is. One mistake could change everything. Like, comment, and subscribe for more shocking courtroom stories and legal analysis.